everybody. This is Crystal Lee, the Groomer's Accountant from Pet Biz Advisors, and this is episode 3 of Beyond the Shears. Today, I am with Michael Gentry and Christopher Critty. Is it Schuele or Schuele? How do you pronounce that?
It's Schuele.
Schuele. Okay, I was completely off. My bad. They are both with Reinhardt Law Firm, and they're located out of Milwaukee, Wisconsin. Is that correct, guys? Milwaukee. Okay. So we're going to start with Christopher Critty, and so he is an attorney at Reinhardt's Labor and Employment Practice. Critty is focused on the human side of corporate law, helping clients resolve the issues that arise between employers and employees and other business stakeholders. He's an experienced litigator and represents clients in a wide variety of business disputes, including breach of fiduciary duty claims, shareholder disputes, and wage and hour actions, both individual and class cases. So, Critty, thank you so much for joining us. If you want to give a little bit more of your background and how you got started in employment labor practice.
Yeah, no, thanks a lot, Crystal, and thanks for having both Michael and I. I got involved in our labor and employment practice in large part because I really enjoy digging through people problems. Our labor and employment practice is really the human side of corporate law. And with that comes many issues in terms of how we as people relate with each other. And I find that it's a great opportunity to really lend our own personal experiences and own touch to what we do as lawyers. And as a litigator, we act as officers of the court. And there's a certain amount of due responsibility there as well that I've always enjoyed participating in. So, yeah, Crystal, thanks for having us and looking forward to continuing our conversation.
Well, thank you for being here today. And then on the other side, we have Michael, and Michael is a shareholder in Reinhardt's Labor and Employment Practice as well, where he assists clients in tackling complicated problems related to their workforces, including protecting their systems and proprietary data. Sounds very interesting, through counseling, contract strategy, negotiations, and litigation. So welcome, Michael. Thank you so much for being here. And tell us a little bit more about yourself and how you got started in employment law.
Absolutely. Yeah. Thanks, Crystal. Again, it's great to be here. We appreciate the opportunity to meet with you and your clients and your audience. I have been doing this for, it's fun to say, a little over a decade at this point. Got started with employment law kind of right out of law school, and it's always been a niche that I really enjoyed. To the Critty's point, I really enjoyed digging into the personal side of business issues, whether that's helping people to prevent problems that arise because of questions around human resources practices, or solving the complicated problems that arise because of disputes or because of other issues that can come up in the employment or other personnel related areas. So great to be here. Looking forward to sharing the time with you.
That's great. Thank you so much, gentlemen. I appreciate it. Okay, so I guess we're going to jump right into it. So obviously, as you are very well known, is that we really mostly deal with pet grooming business owners, which are typically small to medium-sized businesses. And most of them are what we call solopreneurs, right? They kind of do things themselves. They have a single practice. But then several of them decide to branch out. And one of the scariest things for our industry is that when they branch out, they're not really sure how to do it legally, meaning that, what information do I need to do and have set up in order to hire someone in a very protective manner? Because we've all heard horror stories about, employees leaving, trying to sue the individual business owner. They take them to court for, unlawful practices, or what the employee deems as an unlawful practice. So I just want to kind of touch base on a few of those key areas with you guys today. So one question that keeps popping up for my industry area is that I'll have a business owner say, I want to hire a new groomer for my shop. Is there anything that I should know from a legal perspective when I bring someone on board? Like what are some of the things I need to set into place to protect myself when hiring a new employee?
I think that's a good question. And I suppose what I would do if I were counseling a client like this, hey, I want to hire someone. What are the steps that I need to engage in? I think the first questions I would say is, well, who exactly are you looking to hire? and what are the terms and conditions of that employment relationship? I think it's really mission critical for employers to really think through those questions before they start engaging outside with an individual that they're looking to engage, because in particular, the payment method, the amount, obviously those are heavy hitter issues that have to be worked out from the business side. But also, what other aspects of the business and the relationship are we looking to iron out at the front end that can perhaps prevent problems from occurring or disagreements from occurring later in the relationship? Things like scheduling, expectations on where the employee is to be reporting for work. All things that I think are fairly basic, just as a thought exercise, but you'd be surprised how often these sorts of issues come to a head months, years into a relationship. And it always seems to me that there are many issues that can be sorted out at the front end if the employer and the employee are on the same page as to what is expected of him or her before the ball starts rolling.
Sure. That makes sense. Absolutely. So you want to make sure that probably it sounds like you probably get some kind of contract in order that spells all of this out within that contract. Is that something that you would recommend?
Yeah. I mean, I think spelling that out in writing is a way to start the relationship. You mentioned a contract, and I think this can take all sorts of different shapes and sizes.
Yeah.
There are some employees where you want to have a very full-throated contract that's multiple pages, that has all sorts of boilerplate recitals. Other employees, I think you can get by very fairly and reasonably to protect yourself with a pretty standard 1 to 2 page offer letter that memorializes those terms and conditions of employment that I was just alluding to beforehand. And perhaps in addition to that, there's some agreement related to confidentiality of certain company property, things of that nature. Perhaps a restrictive covenant agreement for an appropriate situation. That certainly and should take more of a formal format in terms of an agreement. But oftentimes, I find that employers can do very well with a thoughtful offer letter.
Okay. All right. So obviously it sounds like an offer letter and a contract are kind of two different things here in terms of this context. So do you recommend always having an offer letter before the contract's officially signed? That way, again, you spell out what's expected of the employee-employer relationship?
Yeah. I mean, and Michael, feel free to hop in. I think oftentimes, that offer letter can take the place of, a contract, as I think many people think of it, with lots of legalese and things of that nature. Now, an offer letter that's very, very simple, it certainly is going to spell out what the party's expectations are. So I don't want to importance of being very particular with what an offer letter says and what it doesn't. But for some employees, maybe it's an offer letter to say, hey, we have general terms and conditions. And to your point, Crystal, a more fully formed employment contract is forthcoming, and we expect you to sign that before your first day.
Yeah. Yeah, I agree with all of Chris' comments. I would say that a lot of times what we see our clients do, and, dog grooming companies are really no different than any other small or medium-sized business. I recently helped a veterinarian's office do this exactly the same thing, hire one of their first new employees that they've hired after branching out. But a lot of times our clients will use an offer letter to sort of foreshadow, here are the terms and conditions of employment. However, the start of your employment is conditioned upon a few things. One of them is signing a more formal contract. Another one typically will be passing a background check, which there are rules and regulations around the types of background checks that can be done and what information that you get from a background check can be used in considering whether or not to prevent someone from being your employee, from deciding, hey, I'm not going to hire this person because I've gotten some information from a background check that I don't like. There are discrimination laws that vary from state to state. Obviously, we're sitting here in Wisconsin. Your customers may be all over the place. Your audience might be all over the place. Those are going to differ depending on the jurisdiction, the state that they're in. And then there's also federal laws that apply across the board. The Fair Credit Reporting Act is a law that generally requires employers to provide a notice and get a consent from a potential employee before they conduct a background check. And after they conduct the background check, if an employer is going to say, hey, we're not going to hire you because of what we got from your criminal background check, you generally get the opportunity to sort of provide a response to that. And so there are certain hurdles that an employer wants to make sure that they jump over when bringing somebody on in that regard. A few of the other issues that I think a company should think through doesn't necessarily have to be addressed directly in the letter, but are we hiring this person as an employee, or do we think we can hire this person as an independent contractor? And so there's a myriad of issues there. Each law that regulates the employment relationship is going to have its own individual test as to whether somebody's an employee or an independent contractor. But a lot of the times it kind of boils down to, is this person really just working for me, or are they holding themselves out as a pet groomer to other pet grooming businesses? And they sort of go around to different companies offering this service, in which case it might be more appropriate to be an independent contractor. Related, is this somebody who I can put on salary, or do I have to pay them overtime? In the legal jargon, it's exempt versus non-exempt. And those are tests that an employer should think through when they're deciding what are this person's hours going to be and what are this person's pay going to be, because there's both a requirement that they be paid at a certain level and a requirement that they satisfy certain types of job duties in order to be an exempt employee and not be one that the employer has to pay overtime to if they exceed 40 hours per week typically.
Okay, so what I'm hearing, because I'll oftentimes get the exempt and non-exempt mixed up myself. And so it sounds like the exempt are more salaried type employees. Is that correct? That work a certain number of hours? Or am I getting that mixed up again? Because I always seem to do.
Yeah, no, you have it exactly right. It's
okay.
The exemption is, do I have to pay them overtime? So
Gotcha.
Typically, just as a default, anybody who works more than 40 hours a week deserves to be paid time and a half at the federal level for their pay. But somebody who is exempt, who's paid at a certain level and who has certain types of job duties, generally like a little bit more managerial or executive or certain administrative duties, they do not have to be paid overtime because they are exempt from that requirement.
Absolutely. All right. Thank you so much for clearing that up for me. So yeah, going back to the whole employee versus the independent contractor. Obviously, as my audience knows, episode 1 was strictly with an IRS agent. He's a former agent of 20 years. So he knows all about the employee versus independent contractor. And it is, very interesting within this industry because the pet grooming industry is not regulated, quote unquote. So therefore, they don't have certain rules and requirements. Essentially, what they say is that you can actually graduate high school, pick up a pair of shears and call yourself a dog groomer, which is a little scary, because if you're dealing with my pet, I want to make sure you have some training and experience under your belt, but then that's something that happens. So my goal is doing all of this is to kind of put some form of regulation in the industry a little bit, make regulation a little normal. So that way people have not only protections for the business itself, but then also for the employees and the customers as well. So that way we have everything on one even playing field. So when we do the independent contractor versus employee debate, and I always call it a debate because every time in the chat rooms, it always gets heated because people are like, no, I'm treated as an independent contractor, which, again, if you're looking at, the criteria from both federal and state, they're like, no, you're not. But I did have one individual person who came to me and said, I really think I am because I do go, from shop to shop and I have a specialty technique that I use. I'm like, well, then, yeah, I think you probably would be the one exception to this rule because most groomers that I see are not independent. They're working under the umbrella of that particular business, so to speak. And so that gets a little difficult. But can you maybe speak a little bit more on as far as from the employee standpoint, from the labor law perspective, if they are considered an independent contractor and not an employee, what are some of the protections that they may lose in that independent contractor label?
Yeah, that's a really good question. Someone who's an independent contractor generally speaking, their relationship with the business is then governed by the contract, whatever form that takes. Contracts don't always have to be in writing, but generally, if you are an independent contractor and you think, based on the same type of criteria you were just talking about, Crystal, you've got some specialty technique, you're really selling your expertise to this company. And so if you're looking to protect yourself, you really want to make sure it is in the four corners of that document, because it's true. Generally, a lot of the protections of discrimination laws may not apply. Some of the other like Family Medical Leave Acts may not apply. So if you're trying to secure a certain amount of like ability to get paid while I'm taking time off, that's not necessarily something that the law is going to provide for. So you do want to kind of think through those topics before entering into that contract, so you can spell them out in detail to the best of your ability.
And one thing I would just add to Michael's point, all of which I agree with, just because you put as an employer or a principal a label on a contract, this person, we're deeming you an independent contractor, that doesn't necessarily hold any weight in terms of the actual reality of the situation. Is this person, employee, independent contractor, is this person really in it for themselves, in it for a business of their own? Do they have an opportunity for profit and loss? What's the permanence of the relationship between the principal and the contractor? Is it one where we expect, all of that contractor's revenue to be coming from and this relationship to sort of go on indefinitely? Or is this something where, kind of like you hire a plumber to fix a leaky pipe or a toilet, where it's a one-off job by job sort of engagement? These are the sort of questions that Michael and I would be asking in connection with our practice to really ferret out, well, what's the real nature of this relationship? That's great. You call it one thing or another, but breaking it down into the components, how does it operate on the ground?
Right.
Gotcha.
Yeah. And I would add to that, what in the background, what the business that's contracting with this worker, whether it's an independent contractor or an employee, should be concerned about is they might get audited by one or more federal or state, regulative bodies. You said you have an IRS agent on here. The IRS has its own test, its own set of criteria by which an employer needs to decide, is this an employee, or is this an independent contractor? But, Wisconsin's Department of Workforce Development, which is effectively like the Department of Labor for Wisconsin, has its own criteria that goes towards whether or not an employer is required to take unemployment insurance money out of an employee's paycheck, and whether an employer is required to have workers' compensation insurance. And those are big issues for the DWD, which is, the shorthand for that agency. And so they are apt to audit companies based on the number of workers they have. If they think that a company is employing people as employees, but they're actually misclassifying them as independent contractors, there could be substantial penalties as well as back taxes owed because they're not taking out those unemployment taxes or paying for workers' comp insurance. On top of there's just the potential of legal liability from the employees themselves if they're working more than 40 hours a week, and then they can come back and allege, hey, you owe me all this overtime. So there's a lot of issues that are there in the background when they're trying to hammer out the nature of this relationship.
Yeah, it sounds, the biggest thing is I always tell people, if you are confused, then, ask, always ask, either, talk with one of you guys, or an attorney, a tax attorney as well, to kind of see what the stance would be for their particular situation. Absolutely. And so if we don't mind going back a little bit and going back to the contracts, because that always, fascinates me, because again, those legalese, right? So the offer letter, I think, would stand pretty much on its own, at least for, like you said, the initial offer, just kind of spelling out everything that they need and everything that they're expected to do in terms of the employee-employer relationship. Now, let's talk a little bit more, though, about the contract itself, like a little bit more legal substance, so to speak. what would you recommend being maybe like 3 key components, not everything, but maybe 3 top components that need to be addressed in that legal document of the contract?
And Michael and I, we could probably spitball this back and forth, but I think if this is an employee where an employment contract of some sort is going to be appropriate, I think number one would be some sort of protections for your business's confidential information. It would seem to me that that's a very important aspect to a contract where an individual is going to be dealing with, for example, customer information, have access to proprietary information that a company may develop to further its business. You'd want to make sure that that information is protected in an appropriate and reasonably tailored fashion. Sort of a derivative of that would be if, and again, this is not for every employee, I want to make that very, very clear, but for certain individuals I'm speaking broadly at, industry by industry, whether it's a salesperson or an executive employee that someone may be hiring, a management level employee, there may be a need for a restrictive covenant agreement. And restrictive covenants is a broad umbrella term that can include lots of different types of restrictions. For example, a traditional non-compete prohibits someone from engaging in a competitive business within a particular geographic territory. And that it can expand or contract depending on the type of business involved, the position the individual had, and that's really a legal determination on a case-by-case basis. You can also have customer non-solicitation agreements that would prohibit someone for a period of time post-termination from soliciting a customer he or she did business with while employed by the principal. There's employee non-solicitation provisions, which would effectively operate as an anti-poaching obligation, where someone can't leave, start a business, and poach employees from you that they've come to know through their employment. So restrictive covenants, non-disclosure agreements for confidential information, restrictive covenant engagements, things of that nature, I think often find their ways into formal contracts.
Yeah, and I agree with that. And often when a client is hiring somebody who they know is going to be handling some of that more confidential information, or who is going to be managing more, important customer relationships, that's when we are really interested in making sure that clients are getting those protections into the contract. Like Critty said, it's not for every employee. If the employer is going to be enforcing one of those restrictive covenants, you have to have a legitimate business purpose. Courts are, there's kind of a famous case about Jimmy John's where court said, no, you can't prevent these Jimmy John's sandwich makers from making sandwiches in other shops. It's just not that important, right? It's just kind of as a base layer, you got a legitimate business reason to support those things. But related, I've jotted down a few notes here while Critty was sharing the topics. Related to that is you always want to have something in the employment contract that specifies that an employee is required to return company property, at the end of employment, of course, but really at any time at the employer's demand. Obviously there are legal problems with stealing, regardless of whether, it's in a contract or not. But our clients have found it a lot more easy to enforce a contract that specifies here's when and how you need to return this company property. And that applies to, for your audience, the expensive shears they might have borrowed once or twice to take home to their own pets at home, or, any of the other things that they use for work. But also if there are any employees who are managing the client data, the financial data, or the important kind of sensitive proprietary information that's held by the company, anything. Yeah, exactly. Customer relationships, any of the stuff that they are doing, say on their own personal computer or on their own personal phone, any of that could also be company property, but should be specified as such in the contract. So that's how we always work with clients to make sure that they're getting the maximum protection that they can by including that in the contract. A few other issues that are sort of important to include in the contract that aren't of the same ilk as that is, specify how this person's going to be paid. Are they going to be on salary? Is there going to be a commissions component to it? Generally, if there's going to be a commissions component to the contract, the way we would often structure it is we would say, hey, attached as an exhibit is the commission plan, right? And so what that does is it allows the employer to change the commission plan from sort of month to month as necessary or from year to year without having the employee sign a brand new contract each time. So that's a nice level of flexibility that employers have. And there's a lot of legalese that gets included in the contracts. Generally, you want to specify, what's the nature of the law that applies. Is it going to be Wisconsin law? If there are disputes, are you trying to go to arbitration? Is that something you're interested in? Or do you want to make sure all of these lawsuits are handled in the court that's kind of local to where the business is located? So we could bore you all day with, examples
Yeah.
in a contract, but are of very little interest until the disputes come up,
Exactly. I know it sounds law and taxes and accounting, I think, are like best friends when it comes to just like the this is so interesting club, right? Like we're right there with you. So yeah, thank you guys so much. That really explains a lot. One of the issues that I keep running into with my customers and clients is that the NDAs and the non-competes. Okay. Now, again, I'm going to preface this with I apologize for where I'm getting this information because TikTok seems to be kind of the bane of all of our existences, right? I mean, how to not pay taxes, how to form LLCs to get around paying taxes, and then obviously all kinds of legal issues there. And I won't even get into the thick of it. But one thing I have been hearing and that customers have been asking me are about the NDAs and non-competes. Of course, I don't practice law. I tell them to speak to a lawyer. But what is your viewpoint on that in terms of, let's say an employee leaves and they are giving confidential information about a company after signing an NDA and a non-compete to a competitor, and they're going over there. Or any recourse that the business owner who had the employee sign the contract, what could they do to enforce that on that end?
Yeah, so it does kind of go, don't mean to jump in there, sorry. It does kind of depend on what's in the contract. Lawyers are kind of famous for starting their answers, well, it depends. But in this case, the
it
question
really does.
is, yeah, in this case, the question is, what is confidential information? There are limits on what all can be confidential information. So courts and agencies, they don't like it when you call, basic pay data confidential information, for example, or stuff that's publicly available. If that's called confidential information in your contract, a court might not be willing to enforce that because it's what they would say is overly broad. But in general, if you've got a scope of confidential information properly defined in your contract, and you've got a former employee who's taking that stuff and giving it to a competitor, you have a potential cause of action for what would be breach of contract against the employee, and then potentially tortious interference with contract or something similar like that against the company. If the company knows about the contract that it's basically helping this former employee to violate, then they could also be on the new company, could also be on the hook for liability.
Okay, makes sense. Yeah,
And
because
go ahead. Sorry, Chris, I didn't mean to cut you off.
You're fine. Please go ahead.
I think sort of a derivative of what Michael's saying is, there are different restrictive covenants to solve different problems. And sometimes what I'll hear from clients is, hey, I've got this NDA. It prohibits this employee from disclosing confidential information. Can you use this to make sure they can't go to work for my competitor? And it's like trying to screw something with a hammer. I mean, these are generally speaking different concepts. So I think it's important to know the limits of what your agreement is able to do under the circumstances, and state law can dictate the answer to that question as well. There are some states that take this position on inevitable disclosure. You can't go and work somewhere if you've been very high up at a company where, we as the court, you basically assume you're inevitably going to disclose some of the confidential information at your new employer. Other states, they haven't latched onto that concept. So it can be very difficult to use an NDA alone to prohibit this individual from going to compete. I think it's also worth noting too, running into court with a cause of action. you can get various different forms of remedies from a court. You can seek an injunction from a court, which is a court order saying, stop what you're doing. Stop immediately while we sort out the merits of the case. And that can be extremely helpful on the front end. It's a really involved and very frantic process to get an injunction prohibiting someone from violating an agreement while the litigation is. But it's certainly a possible and very powerful remedy. Alternatively, you can litigate something all the way to the end and seek monetary damages. Hey, because you disclosed this information, my company's been damaged in an amount equal to X. It's an expensive and very long exercise to work your way through the court system, but it's certainly possible. One thing that can be helpful, and again, this really depends on what state law is involved, but having an attorney fee shifting provision in a contract can be a very, very useful tool when you are seeking to enforce a restriction, because it's an expensive endeavor and perhaps there's a prevailing party concept for attorney's fees, and that wouldn't be the default under the law generally in many states, but you could factor that into a contract.
So the attorney fee shifting, is that where the person that's being brought to court because of their actions is basically responsible for paying for those fees in order to do that? Or am I misinterpreting that?
No, I mean, that can be the way a provision is drafted. You can also have a provision drafted such that whoever wins pays the other side's attorney's fees. So it's sort of a sliding scale approach to it. And again, it really depends on the contract and what's in it. Michael and I spend lots of our time scrutinizing particular language, oftentimes language that wasn't drafted by us, to try and come up with various arguments for either enforceability or unenforceability of a restrictive covenant. And quite seriously, I mean, it can depend critically on one or two stray words that can change the meaning of a contract. And some states are more willing to enforce restrictive covenants than others. California, North Dakota, Oklahoma are notorious, now Minnesota, notorious for being very opposed to enforcing non-competes because they have a state statute that may ban it entirely, or case law that's developed that's very, very reticent to have a court enforce something like that of a restriction. A state like Texas, it's the opposite side of the same coin, where courts are held to be to enforce restrictions to the extent reasonable under the circumstances. Wisconsin tends to lean more to the side of it's difficult to enforce a non-compete here, no question, but it's not impossible. That's a myth that I often hear, so much in terms of our clientele, but just, talk about what we do and, non-competes, those aren't enforceable, right? And it's like, well, no, they can be, but they've got to be narrowly tailored and very well drafted.
It definitely sounds like that's something that I also was hearing a lot on social media. Well, don't worry about it because it's not enforceable anyway. I can't tell you how many times I've heard that. And I'm like, well, it probably, like you just said, it just depends on how it's drafted and what the language is behind it. And also the importance of getting it done within your state, because I think a lot of people tend to go on like these places like LegalZoom and things like that, and they get these contracts drafted and these non-competes and things. And the thing is, I cringe a little bit, like going from that. It's like, it's equivalent of someone in my industry using TurboTax. It's like, yeah, it's quick and easy and it's cheaper typically, but you are not going to get that level of, detail that you guys can offer on independent and individual basis for that particular business. It's day and night. So it honestly can be a little scary at times with some of the things that they leave out. That's what I mostly see, is the questions they don't ask and the things that they leave out in those contracts.
Right.
So
yeah, Crystal, one of the issues that we run into is, a client will come to us, with the, well-intentioned purpose of getting contract ironed out for a particular employee. And then they'll be like, all right, check that box. Got that done. Now I never have to talk to the lawyer again. And so use the same contract for everybody, regardless of where they're at, not knowing that, whoops, we just had a California-based employee sign something that the California courts deem illegal. It's actually worse than even if they hadn't had a contract signed to begin with. So there are a lot of issues, and where the employee is based, that's typically how those jurisdictional questions are answered. But, it's always worth thinking about every time you have someone new sign a contract.
Yeah, that's a really good point. Thank you for sharing that. So here's another fun one that I have seen recently. And honestly, I have employees myself. I own a laundromat and I have employees myself. So sometimes I get a little, questionable about this. So let's talk about fee deductions from paychecks for employees. The business owner, are they legally able to deduct fees from an employee's paycheck to reimburse for things like supplies, damage, theft, anything like that?
So I actually just had this looked at for a client who has offices in various states. So I feel relatively well positioned to start off answering it. It depends. State. So again, I think it's going to depend on what state the employee is based in. But the states are kind of across the map in terms of whether you can deduct for, sort of like faulty workmanship or loss or breaking something, whether you can do that at all, and whether you can do that with a authorization that is signed by the employee before or after the work has been faulty or the loss has occurred. So, for example, in one of your audiences, businesses, there might be some expensive machine that an employee breaks. And if they have the employee sign something that says you can deduct, X percentage of the loss from my paycheck, and they have them sign that after the loss has occurred, then that might be an enforceable deduction because you've had the employee authorize it after the fact. The employee has the choice. I kind of want to keep this job. I'm gonna agree to this deduction. Versus if you have just in an offer letter or something that says, hey, we're going to charge you for anything you break while you're employed. Fewer states are going to enforce that type of deduction. And in fact, there could be penalties imposed against the employer for wrongfully deducting something without having the employee sign an authorization, that follows the loss or something like that. Ran into this with a client that has employees who drive trucks for their company. So trying to decrease the amount of, accidents an employees are getting into and looking at what sticks can we impose by, requiring an employee to pay some of this. And in a lot of states, you can't do that unless there's some agreement by the employee after the fact, after the accident or after the loss has occurred.
Okay. Yeah, makes sense. So definitely, it sounds more like check with the state, make sure that you even can enforce that. But if you can, it needs to be in writing at the very least, signed by the employee.
Right. Yeah, it kind of gets down to, unless you've got some agreement with the employee that dictates, whether they're going to be employed for a certain amount of time. Generally speaking, employees in most states are at will. And so if you approach an employee and says, hey, you just wrecked this really expensive machinery, I'm going to fire you unless you agree to pay some of this. That's generally an enforceable thing that they can do. May not be the best business practice, but nonetheless, if that employee is going to sign an authorization to have some amount deducted after the fact, then that could be an enforceable deduction.
Okay. All right. Makes sense. I guess also it probably is something that goes back to the offer letter that we were talking about earlier too, is to kind of maybe spell some of that out as well. It could be maybe like the bottom section of the offer letters. I mean, this is kind of like our practice, what we normally do here at this salon or the shop, and make sure that they understand going into that, or at least the contract itself, within the legalese of the contract, and make sure that they understand that.
Crystal, I'd even, pose maybe a different potential solution for that too. Not so much with the payroll deduction that Michael's just spoke to, but just general policies of a company. An employment contract, an offer letter does not need to include every single policy that the company has. In fact, I think Michael and I would both agree that it's better to have that memorialized in an employee handbook, in something that all employees have access to, that the company can change without having to renegotiate a contract, for example. And we strongly recommend that employers use an employee handbook, not because you wouldn't have the ability to take certain actions without one, but really, I think that the benefit of an employee handbook goes back to a point that I made glancingly earlier in this call. Problems can be avoided between employers and employees if people are on the same page from the outset. And even if an employee doesn't read and memorize every single page of an employee handbook, it can be extremely valuable for an employer to go to an employee when an issue arises and says, hey, we've actually thought through this issue. This is the company's policy on that. This was provided to you. This is how we're going to deal with it. And it ensures some level of perceived fairness between an employer and an employee that can go a long way. It can go a tremendously long way. Oftentimes, Michael and I will get questions about, how do we avoid, issues that, seem to creep up with the employees at our workforce? What are some general thoughts there? I think making sure that you take every step to ensure that the relationship is fair, is transparent, and is one where the employer and the employee both appreciate the contributions of the other, I think is critical, and an employee handbook can help you with that.
Absolutely. I'm so glad you brought that up, because actually in my personal business life, that's actually come to fruition for me, because I had an employee that I had to let go for various reasons. And one of the unemployment agents called me, and they were trying to get on unemployment. The thing is, technically with what they did, they were really not eligible for this. But they asked me specifically to send them a copy of my handbook where it says in that this is how we are going to treat this particular situation. And so I was obviously case closed. As soon as she saw that, she said, we're done. That's it. It's in there. So yeah, so employee handbooks, like you said, can actually cover a big group of your, do's and don'ts within the company, and make sure that the employees understand what's spelled out within that company, and saves you, like you said, from a huge contract that might be like 500 pages long. And so that's what the handbooks are for. So absolutely. So, who do you recommend that my audience could possibly use to get one of those handbooks created? Do you have services that you guys offer like that, or do you send them outsourced to somewhere?
I'm going to recommend Michael Gentry over to my site.
There you go. Yeah.
No, our firm can certainly help with that.
Sure.
It's something that we advise and assist clients with.
Yeah, we have various templates for the states where most of our clients operate in. A lot of times too, our clients will come to us with some template they've gotten from a legal adjacent entity, whether it's like LegalZoom, like you mentioned before, or something else, and we'll sort of spot check for them. Here's what is in our template, and the stuff that we would generally recommend you add. So there's a lot of ways to do it. It's certainly probably not always efficient to simply create one whole cloth. It would be very expensive and time-consuming endeavor. But luckily, there's no need to do that, because we've got one certainly for Wisconsin and other places where we have clients to get most of those requests off the ground with very little effort.
Sure. Sounds great. All right. Before we leave, I'll make sure I get your contact information before we close out for the podcast. That way they know how to get in touch with you guys. So I have kind of a 2-part question. This is kind of a fun one, but I hear about this all the time. So if an employee is injured on the job, what are the legal responsibilities of the employer in order to assist to make sure that they are taken care of? And we will like play pretend here that they do have an employee-employer contractual agreement. So what would be the employer's responsibility to make sure that the employee is taken care of in that reasonable?
So to be very clear, neither Critty nor I practices workers' compensation law.
Okay, that's fine. That's fine.
A lot of people do make that mistake to think that, well, you guys do employment law, you must do workers' comp. So
I gotcha.
We may know enough to be dangerous, but this is not even coming from workers' comp insurance counsel. But generally, creating a report, following whatever procedure you have in your handbook, which likely does have some element of a protocol for here's exactly what does happen should be some sort of injury report, a requirement that employees report injuries to begin with, creating that level of report and making sure employees get the medical attention that they need, I'd say is paramount. Not only from like a, best practice liability avoidance standpoint, but just from a human level, obviously.
The common sense, yeah.
That people are taken care of and aren't working under a strenuous injury on the job.
And it's implicit in what Michael said, but obviously notify your carrier as well, so that they can start moving with their obligations to you as well. But yeah,
yeah, that's a whole other, I guess, obviously, sorry about that. Workers' comp is a whole other section. And trust me, it is very interesting. My uncle actually used to be a workers' comp enforcer in the state of Tennessee. So that's always a fun thing. So he would be the guy that would walk into the business and shut it down if they weren't doing things appropriately.
Oh, wow.
Yeah. He was pretty hardcore with that. Okay, well, maybe on the flip side of that, and again, this could be the same scenario, and if it is, just stop me. But let's say an employee hurts an animal, okay? And then there is a liability on that shop, so to speak, to actually pay. One of the things that I see a lot is that the groomer will say, the business owner is forcing me to pay for this vet visit. Is that enforceable, or is that something, and let's say, for example, it's not in the contract. Let's say that they don't have that the employee has to pay for things like that. They're just saying, well, it's your fault. You have to pay for that. What would your recommendation be?
And Crystal, just so I'm clear, so the question is, can an employer require the groomer who, let's say accident, stabbed or, somehow injured one of the animals, can the employer require the groomer to take on the legal responsibility associated with that injury, whether it's paying a vet bill or what have you?
Exactly. Yeah.
That's interesting. Truthfully, I'd want to chew on that a little bit. And I would have to go back to what the employer independent contractor relationship or status is. I think that would dictate some of it. But I think perhaps, I'd be curious to know if any applicable states' payroll deduction law would have anything sort of related or instructive on that point. But I'd be curious to know. I don't know that I'd have a firm position on that one way or the other. I'd want to think through that a little more.
Yeah, I think so. I mean, I think it would be addressed, and at least that would be one of the appropriate frameworks to sort of look at this through. Is to say, okay, so this is a damage of, a form of property that occurred on the employer's premises. Can you require the employee to pay for that damage? And that would go back to what we discussed before in terms of certain states allow you to do so with authorizations. Other states allow you to do so, but only if you get the employee's authorization after the injury to the animal has occurred here, which would be the most likely case for it to be enforced. But generally, to Critty's point, I think that it would break down in terms of whether it's an employee or an independent contractor, because oftentimes a legitimate independent contractor is going to have spelled out in the independent contractor relationship who is required to indemnify whom, meaning like the company where this is happening, or the independent contractor that holds himself out as the specialist groomer, who is really responsible for any losses that occur. And so you'd want to look at that contract. You'd also want to look at, are there any agreements that these customers are signing when they're having their animals dropped off? And how does that come into play? And are those themselves enforceable? Because, if it's treated similarly to what are called like exculpatory contracts, where you go and sign some waiver before you enter into a facility, those are only enforceable to a certain extent. Courts don't enforce those. I hereby deem that anything in the world that happens to me is off limits. I can't sue under any circumstances. It's probably not going to be enforceable. So it's probably not going to be enforceable if it's the case that a customer is signing something like that when they're dropping their animal off at the shop field.
I suppose there's another thought too. Let's say the individual says, well, I'm not paying for that, regardless of what a contract says. I would wonder too, wouldn't the customer have a right of action against the company if the company is holding this individual out as its agent? Again, this goes to the laws of agency, but it'd be interesting to play that out from a liability standpoint too, assuming that there wasn't a voluntary cooperation with either a contract or a policy or what have you.
Because I'll be honest, I've actually seen this several times in these groups. The groups that I am involved in, there's thousands. I mean, I'm talking over 30 to 40,000 individual groomers in these groups. And several of them have said, this has happened to me. My boss has forced me to pay for this vet visit and things. Of course, we come back with, well, don't they have insurance themselves? Can they not utilize their insurance, especially if the groomer is the employee and not an independent contractor, which is another thing. But yeah, it kind of gets out in the weeds a little bit because, like you said, it completely depends on what's spelled out in the contracts. And I'm going to be fully honest here that I don't think a lot of these people have contracts with their employees. I really just don't. A lot of them are smaller and they have 3 or 4 maybe employees. And the thing is, guys, and I'm going to say this right now for all of you, even if you have 1 employee, you need to have a contract. It's just good common practice for you guys. And so therefore you have everything spelled out. So you're not having to wonder, am I covered? Am I not? And so the same thing goes for the employee side. Make sure you're signing the contracts. Make sure you know what you're getting paid, when you're getting paid, how you're getting paid. Make sure you are covered by workers' comp and various general liability insurances. And all of that would be spelled out in these contracts. So that way there's no question for what you need to do. So now we're going to kind of wrap things up, but I want to talk a little bit about terminations. That's another thing that my audience has issues with as far as how to do this appropriately. So for you guys, what are some of the common legal mistakes that occur when people are terminating that you have seen in the past? Just generalized. What are some mistakes that the employer has when terminating an employee?
I suspect Michael and I will have very similar experience here, but oftentimes in these sorts of settings, I'll get a call from a client. They'll say, we want to terminate this person, tomorrow, Friday, whatever it is. We've thought a lot about this and we have all these reasons. They haven't done this. They haven't done that. And this is the reason for the termination. And it's a legitimate, non-discriminatory reason. Question number 1 I ask is any of this documented? And a lot of the time it's, well, no. Okay. Does the employee know that they've done anything inappropriate? That's okay. It's not documented. Would prefer that it was. Have you talked to the employee about this? Well, no. Okay. Well, this is going to come out of absolutely nowhere for this employee. And really, I mean this. We deal with companies that want to operate within the bounds of the law. And a lot of what I tend to find myself advising clients on is this is a legitimate non-discriminatory reason for a termination decision. Agreed. But how is this going to appear to the employee? Is the employee going to be totally blindsided by this? If so, there's a higher likelihood that this is going to bubble up into something and take on a life of its own. So I think document, and make sure you're having difficult discussions with your employees. Again, I feel like this is really kind of a loop for our listeners here, but employees shouldn't be surprised by company policies, company expectations, and candidly, employees shouldn't be surprised if and when their employment ends. There should be some record. Yes, in Wisconsin, we're an at-will state. Many states are at-will. But that doesn't mean it's not best practice to really lay the groundwork, lay the foundation for decisions so that they don't come out of nowhere and people aren't totally surprised.
Yeah, I completely agree with Critty. A lot of times these conversations take place through the lens of what are the risks here and what will we say if this person files a claim? Would that often might be some type of discrimination claim with a state agency or the EEOC. And the nature of that complaint could be frankly, it could be really frivolous. It could not have much merit, but you as the employer are still going to have to respond to it. And, legal fees are expensive, and that's a hassle and a process you don't necessarily want to have to go through. And so that's why we talk to our clients about having that documentation in hand to be able to say, no, what they said in their complaint about why I terminated them, it's completely false. Here's the documentation. Here's where we talk to them multiple steps along the way. They know exactly why they were terminated. So that's generally going to yield a more successful outcome if one of those complaints is filed. But often, if someone is not going to know that they're being fired, we talk to our clients about, well, would you like to offer this person a separation agreement? Would you like to offer them the opportunity to sign a release of claims or some type of severance? And that doesn't have to be a lot of money. The law does not say you have to have $5,000 minimum as a severance. There's nothing like that. There has to be what's called consideration for a contract. So you can't just say, hey, I'm going to hold your last paycheck until you sign this agreement releasing your claims, because they are already entitled to that money because they already did that work. But if you decide you want to pay more money on top of what they already owe them, or provide some other level of agreement, maybe it's offering them the opportunity to pay for their COBRA health insurance coverage. There are other things that you can offer as an employer to get an agreement on a separation agreement. But in any event, that's another example of how we would counsel employers about how to avoid that risk if you're not sure that an employee might or might not file a claim against the company after termination.
That's awesome. Thank you guys so much. Honestly, you're both rock stars in my opinion. You both have really given us a lot of information. I know you've answered a lot of my even personal questions. I was like, I need to make mental notes of that. So I'm definitely going to go back and watch this again and say, okay, I need to utilize this. And I might be calling, I know definitely Michael soon to help kind of beef up my employee handbook for sure. So if you don't mind, if you want to share your contact information or the best way to get in touch with you guys, for our listening audience, if they have questions about handbooks or just employment law in general, how can I get in touch with you with that?
I would say going to Reinhardt's website, reinhardtlaw.com. Both of our bios are up there. It's got our direct phone lines and our email addresses. And certainly I'm happy to send you, Crystal, I'm sure we're both happy to send you our business cards, any other way that we can kind of put it in the show notes, as they might say in the that would be very helpful.
Yeah, definitely. So for everybody, that's watching this on YouTube, I will have a link in the description below. So make sure you also like and subscribe to that. But then also you can find their contact information for the websites. And those of you that are listening on Apple and Spotify podcasts, I will put something on the actual show notes, as Michael was just saying. So you will have some type of link that you can click on with that. So guys, thank you so much. It's been a pleasure. We have learned so much from you. And I hope that you have a wonderful day. And to everyone else, thank you for watching Beyond the Shears. And we will talk to you soon. Thanks. Bye.